introduction to the panel discussion on this particular topic, that is Withdrawal of Advocates Amendment Bill 2025.
Mm-hmm.
Now, this topic is trending, and the reason we are discussing about this specific topic is that it has been recently withdrawn, and
Mm-hmm.
there were much protests against this move. So today we are joined with Advocate Navneeta, who is the founder of Nava Legal, specializing in finance, leasing, and securitization. With expertise in contract drafting and also he navigates across the cases like DRT, NCLT, arbitration, 138, Negotiable Instrument Act, civil and criminal law as well. So before we begin with discussing this much awaited topic, let's watch a video of what is the case is exactly.
Hello.
In a world where time is precious, getting
Come
swift
again.
access to legal
Hello?
help shouldn't be a privilege, but a right.
Yes, sir.
You ask me any question to me now?
No, no, sir. Just we are shooting
Okay,
this.
okay. Okay.
After that, we'll start with this.
The voice is breaking somewhere.
Am I audible now?
Now audible.
Yes, yes.
Welcome to Rest the Case, India's most trusted online platform for legal solutions. We are transforming the legal tech landscape, bridging gaps, and bringing legal support to anyone, anywhere, at any time. The legal field in India can be overwhelming. Courts are crowded, the search for the right legal help is confusing, and legal fees can be unpredictable. Many litigants face trust issues, uncertain about finding a lawyer who truly understands their needs. Rest the Case solves this by providing verified lawyer profiles, making it easier than ever to find trusted legal support.
We all are aware of that lawyers are not allowed to advertise themselves, right? But again, they do need something else going on from their routine practice, just so that there are people who actually know about them, so that they can reach out to them without any hassle and easily.
That's where Rest the Case steps in. From consultations to document drafting and court representation, our digital platform brings legal expertise to your fingertips.
The legal ecosystem is a triangle: judiciary, litigant, and the lawyer. But we are touching the litigants, both B2C, retail, and B2B corporates, and the lawyers. So our tools will make life simpler for litigants, retail, by helping them reach the right lawyers. We are using GenAI, we are creating an improved matching system. And for B2B, which is for startups and mid-level corporates, we are helping them by doing tasks like document draft creation, also other aspects which relates to their internal process improvement.
Powered by cutting-edge technology, our platform leverages AI to match users with the most suitable lawyers. Based on expertise and location, from its start, Rest the Case has grown rapidly. With a presence across India, our mission is to provide legal accessibility everywhere, from big cities to smaller towns.
Our vision is to make legal support accessible and affordable for everyone in India. Our journey began in the lockdown, where suddenly people did not know what to do or where to find the right legal support. We then realized that this is not just a pandemic issue. This is an issue that people face every day and everywhere. That's how Rest the Case was born. We bridged the gap between a lawyer and a client to give them a reliable place to find the right legal help.
Rest the Case, because every case deserves the right support.
So yeah, now we know what is the case is. So let's start with today's discussion. Let's delve into the pressing questions and move beyond resistance to explore the future of legal reform in India. So, sir, I think let's directly start with the bigger picture. Why was the bill withdrawn? So, was the withdrawal of the bill a victory for lawyers, or is there any sort of missed opportunity for legal reform in India?
Of course, the withdrawal is for the good of lawyers. It is because of the lawyers' protest only this amendment proposed was withdrawn.
Mhm.
There are so many provisions which is against advocates, anti-advocates provisions. So I support this withdrawal. The government has to rethink, reconsider, and take into account the objection made by the advocates and accordingly make amendments
Okay,
for the good of the lawyers to protect the interest of the lawyers.
right. So I mean, you also agree that the government actually somehow failed to engage meaningfully with legal community before actually drafting the bill,
Yes, of course. Even up, there's a deliberation discussion, and that was not reflected in the proposed bill.
right? Okay. So, you think could the withdrawal set a precedent where strong opposition from the legal fraternity forces the government to back down on reforms?
Yes, of course. See, advocates are expected to protect the interest of clients, citizens, even for the government. When the advocates themselves cannot protect their interest, how can they be expected to protect the interest of the rest of the community?
Right,
So
right,
we have to be very firm. Loyal community is the community against which government will also think twice. Even judiciary will also think twice. Even other machineries, organs of the government will also think twice, because advocates' role in the society is so important
mm,
that they cannot be sidelined.
correct,
Because these communities are the one which safeguard the constitution and democracy. So we should respect advocates and their interests. If their interest is not protected, ultimately it won't protect the interest of anyone else.
right. I mean, that's the basic thing what
Yeah.
advocates must be doing. So, you think how can legal misconduct be addressed more effectively without infringing on advocates' independence?
Yes, because we have an internal system. There's a bar council, state bar council of India, and bar council of state bar council.
Correct.
They are the governing body.
Right.
So they have the expertise, and they have the mechanism. They have the power to deal with all this kind of misconduct by the advocates.
Mm.
So government interference will tantamount to say infringement of autonomy
Right.
or independence.
Right.
See, bar and bench are considered to be the two wheels of the same chariot of justice.
Correct.
Bar and bench. It is not that independence of judiciary means it is not the independence of advocates. Without
Right.
the independence of advocates, there cannot be independence of judiciary.
Right.
That is most important. Even bar is considered to be the mother of bench.
Right.
Even the judges who come to the bench, they are from the legal community. They are from the advocates community.
Okay.
So independence of bar is paramount, very important to safeguard the independence of judiciary. So government interference, they should never try to interfere or to tread upon the domain of advocates.
Right. So in last, I would say, couple of years, we have seen judiciary being, I would say, not exactly the way it used to be because of these actions, I must say. So, you think the protests which we saw can then be held liable or accountable to disrupt judicial proceedings? Because that is what being portrayed out there.
Mhm. So it's a constitutional right. We have fundamental right to freedom of speech and expression. So
Right.
once our interests are aggrieved and adversely affected,
Mhm.
then we have right to protest. That is what they want to curtail
Mhm.
because of this amendment and the bill.
Correct.
So when all the organs of the government or the other departments of the government,
Mhm.
employees, they can protest if anything gone against them
Mhm.
to safeguard their interest. So advocate community should also have the right to protest peacefully. I am not saying violent protest.
Right. Right.
Advocate should not use violence. It should be peaceful. So as long as it is peaceful, I am completely advocating such a protest.
Mhm.
And it is for the good of the judiciary. Now, if the protest, if some judges found to be, corrupt and
Mhm.
still in power,
Right. Right.
then if not advocate community, who
Then,
else will raise
correct.
objections?
Right.
So if a corrupt whatever it is, corruption, a person shall be deemed to be innocent until and unless his guilt is proved.
Right.
But it must be fair. A person who is in power is accused of any offense. He should not use his power. He should be relieved of his duties.
Right.
If such a situation arises,
Mm.
and recently Allahabad High Court Bar Association protested.
Right. Right. Right.
So that is the right of the advocates.
Right.
If advocates do not resist or object it or protest it, which community can?
Well, right.
So
Well
we
said.
should exercise our power. We don't want corrupt judges in judiciary. That is because judiciary is only one organ of the government where the people had that much trust, but that is now being deteriorated.
Correct. Very true, sir.
Yes. So if the faith of the judiciary is gone, then where the democracy will lie,
So true. So true,
where the
sir.
transparency will lie,
Right.
all the government dealings, etc., it is scrutinized by, reviewed by judiciary. In India, we have got review power. Judiciary has got review power. A parliament, if passes any law, that can be reviewed by the judiciary, by High Court and Supreme Court. That is not there in England, Great Britain, or
Right.
United Kingdom. But in India, we have. So this kind of power is given to judiciary, and people have that much faith in judiciary. And if anyone is found to be corrupt, then what is expected of Supreme Court and High Court is not to just mere transfer that person.
Exactly.
That is something as advocate we feel ashamed of.
No, that we all agree with.
Yes. So when in this kind of situation, if you don't protest, then who else will protest?
Right.
So whether our right to protest can be taken away by any statute, my answer is no. As long as it is peaceful.
Right. Well said, sir. If not advocates, then who?
Yes.
So moving ahead with this discussion, that when the bill was introduced, so it had mentioned that corporate advocates and foreign legal professionals might also be considered under this act. So, do you think that would have been a tough competition, or it would dilute the credibility?
No, because that is allowed as long as reciprocal countries, like in those countries where Indian advocates are allowed to practice,
Hmm.
from there the advocates can be allowed to practice here in India.
Okay.
We cannot say we can't blow hot and cold at the same time. We can't say that they should not be allowed and we should be permitted in their countries.
Right.
So that is no, it's not big competition should be there.
Hmm.
Why would one would think of not giving a better service to the client?
Right.
Those who are, no, it is a competitive field. It has been a competitive field, tough field. One has to be competent enough. So we should not be afraid of the competition. We should equip ourselves. We should upgrade. We should enhance our knowledge. So we should welcome it. If anybody thinks that another is far better than us, that person should prevail.
Okay.
But it's a good stand that the foreign lawyers are coming, and wherein we can also go and practice.
Right.
That is good. We welcome it.
So, I mean, introducing corporate lawyers and foreign law firms was not an issue.
Yes, not an issue. Yeah.
Okay, understood.
That is good for us because there are so many people working outside in Britain, America. There are Indian lawyers practicing over there.
Right. And so, moving with this very topic about the foreign.
I would like to add one more thing.
Yes,
It's
yes,
not a
please.
court practice they are talking about.
Right.
It's not
Right.
other areas where they can
Right,
practice,
right.
also, not
Of
in
course.
court practice. Yes.
Yeah, of course. I mean, court practice anyway is not possible.
Yes.
Yes. So what do you think? How can foreign lawyers be regulated to prevent monopolization by large global firms, which we generally see in foreign countries? How, if the foreign law firms are allowed in India, how the monopolization can be controlled or stopped?
That is, see, I respect Indian lawyers. They have much legal acumen. We are not something to be lagged behind.
Right.
So this kind of global can't be a threat to Indian. Even law firms, they are hiring Indian lawyers.
Right.
Yeah, we are doing their work because maybe it's a monetary benefit or what. But Indian lawyers are very competent, talented, though they cannot give a cut, except the financial part of it,
Yeah.
law firm, infrastructure, etc., etc. In that it would differ. But
Mm.
as far as legal competence is concerned, I respect Indian lawyers and they have the legal acumen and they can compete with any foreign law firm, except the financial side of it, which only the person who is having financially well off can
Okay.
provide such a setup.
Right. So, I mean, according to you, that Indian lawyers and law firms are very well prepared
Yes,
to accept, and I won't say competition, but a healthy competition between Indian law
perfectly.
firms
And it
and
has to be there. Legal, it has to
yes,
be there.
yeah. I mean, that is that I would say is very necessary because that somehow increases your capacity as well. It
And that's what
increases.
I told. One has to enhance their legal capacity,
Correct.
legal knowledge, legal acumen, drafting skill, argument skill, everything. And I'm very proud of Indian lawyers. Even in Mumbai, I
Right.
can see there are so many lawyers arguing so well.
Right.
I sometimes wonders. So it is not that I don't have that much faith in the legal system in India or the advocates over here. So legal, as you said, it won't be a threat.
Right.
Even they can learn a lot of things from us.
No, definitely.
Even we can also vice versa.
Yeah.
And what I said, if whoever gives a better service should be given a chance.
Right. So, I mean, this also gives an sort of opportunity to the client
Yes.
to get a better service from a law firm or an individual, right?
Yeah.
Okay. So, I mean, there won't be some sort of, there won't be
Even
this.
the foreign lawyers would be using the service of the Indian lawyers
Right.
in the law firm.
Right. So, but what do you think could be disadvantage if we see the advantages now? Now, what could be the disadvantage, possible disadvantages?
Only thing that see economy, the financial soundness of in the foreign law firm, that could be the only thing that will bothering us.
Okay.
For example, any big corporate
Mhm.
can eat up in a small retail shops, as you know what
Right.
we. So similarly, it will happen. That is a financial power.
Mhm.
That is not nothing to do with the legal. It happens in every area.
Right. So, you think if a foreign law firm comes to India
Mm.
and since as per Rule 36,
Mm.
there can't be any sort of advertisement of any
Mm.
legal practitioner or a law firm, you
Mhm.
think that can be influenced and somehow down the line this can be changed?
In a foreign law firms, if they are in India, they have to abide by Indian law.
Right.
Okay, there are some relaxation in the foreign countries as far as advocates and advertisements are concerned. But bar council need to think
Mm.
the advertisement part of it.
Mm.
See, we can see law has been situation is not as it is as 10 years ago.
Right.
Everything is digital.
Right.
If a person who is well equipped, well talented lawyer, if he cannot expose himself
Right.
a platform to perform,
Mm.
then what is use of his talent?
True. Very true.
Yes, so this kind of talented, that is the main thing, because here if a law graduate, even he's highly qualified, highly talented, he's having a passion towards this profession, but there's no platform. Even if he joins a law firm in that doesn't pay him, then
Right.
how can he survive?
Right.
So there are so many digital media wherein he can express, he can convey his knowledge, share his knowledge, etc. That can be done. That is also allowed nowadays. After 2008 guidelines,
Yeah.
we can have our own website and etc. That's a
Right.
good part, a good move.
Yeah.
And stringent policy that advertisement, it should not be apparent, very apparent that he's advertising for this. But
Right.
sharing knowledge, teaching, writing books, Instagram,
Mm.
wherein all LinkedIn, Facebook, he can show. He
Yeah.
can sell himself in the means that he can show to the public that he's having qualification, he's having the
Right.
knowledge, etc. There
I
is no
think
bar.
that
There should not be any bar as such.
right, and ultimately it helps client to understand that better, I would say.
Yes,
And
and the
if it,
rest the law is doing a wonderful job, a
right.
remarkable job, giving opportunity all
Mm.
people to come and participate in the discussion, sharing the knowledge, and it in a way promoting the juniors
Right.
I was expecting that in the last time also when I participated, I was expecting juniors, and I told this Russell Law, let the juniors be given opportunity,
Right.
with senior. So I want this is a golden opportunity. They should have made use of.
Yeah,
There
exactly.
will
I
be
mean,
n number of participants, and Russell Law is giving in a golden opportunity to them, and they are not realizing it. It is really surprising.
I mean, we all agree with that.
Yeah, but yeah, starting stage now. See, after 2 years, 3 years, people will be in line in queue to be,
Yes.
to participate in this kind of discussion.
Hopefully, hope for that.
Yeah.
Uh, so, how do you think Bar Council should regulate on frequency of? Since we are talking about the protests as well, and I'm
Hmm.
not talking about the strikes.
Hmm.
How do you think Bar Council should regulate the frequency of these protests and not infringe the right to protest?
Bar council should not be subservient to judiciary.
Right.
Bar council has the power.
Hmm.
It should not see subservient to judiciary, Supreme Court, and High Courts.
Hmm.
It will demoralize advocates
Right.
and the faith in the institution, the
Hmm.
Bar Council of India. We expect the Bar Council of India to stand firm with us.
Hmm.
Even a judiciary takes action against a lawyer,
Hmm.
even under contempt of court, and Bar Council finds that. And it's a rule. I have to represent my client's case boldly and without any fear.
Correct.
Otherwise, how can I protect my client?
Right.
So, in that process, if High Court's judge's ego is hurt and takes initiative for contempt, then
Right.
Bar Council should be the one should stand behind us,
Right.
in front of us, behind us as well.
Right.
That will deter the judicial officers, judges, Supreme Court judges, High Court judges,
Hmm.
to take action against advocates, because they should also consider we are office of the court. Sometimes the attitude of the judges, I am very much hurt. The kind of language they speak, the body language, everything of that of a landlord,
Hmm.
feudal lord, that should not be permitted.
Right. That I mean that I agree. So since we are talking about the withdrawal of this amendment bill, so we saw there were good reforms as well that could have been implemented. But
Mhm.
I mean, protest was necessary. We understood. But do you think because of these protests,
Mhm.
the actual reforms like introducing corporate lawyers and foreign law firms, that reform is delayed now?
Yeah, the government, it is not that there's an end to it.
Hmm.
Government can negotiate now, have a further discussion.
Right.
Yeah, those which are completely apparently against the interest of the lawyers should be done
Hmm.
away with. They
Hmm.
can bring in back the good provisions,
Okay.
and bar council would be welcoming it. They
Understood.
have no issues.
Okay.
So
So
one thing is that Bar Council of India, see, that is what we respect our institution,
right.
alliance to my institution. Their interest to be 100%
Hmm.
protected. The government should give weightage to that,
Hmm.
and government should not introduce people, from outside.
Hmm.
That is other interference that is introduced in the bill. Bar Council of India knows how to manage itself.
Yeah. For a reason, it's a bar council of India.
Bar Council and decentralization should also take place. For example, here also so much powers given to Bar Council of India with due respect.
Hmm.
State Bar Council should also given the power. Their power should not be infringed.
Right. Right. So let's suppose this bill is came into force again, where
Mhm.
it is being enacted and reintroduced. So what you, as per your understanding, what safeguards should be taken while addressing this?
Safeguard, as I said, the good provisions are welcome.
Hmm.
There we have no objections, and there are good provisions. For example, you can see 2.1 expanded definition of legal practitioners.
Right.
That is the one thing, and there are so many 3.4, 3.5 condition laid down for voting, contesting electoral roles, including qualified and verified advocates. This is
Right.
one thing good about it, and I can say for 1B, we say up to eminent women advocates.
Right.
These are good part of it. And 6DD and 6GG, State Bar Council to regulate bar associations and inspect legal education institutions. These are the good things about this.
Right.
If I go, then there are so many. If
Yeah.
you want to narrate, I can
Well,
pinpoint one
that
one one.
that is why I mean this thought came that there were many good reforms, but
Yes.
being withdrawn, so we need to wait again.
No, I can see good or bad. Government should not introduce their nominee.
Right.
Government has no business, should not have any business with it.
Hmm.
Even I say the independence of judiciary, that is also paramount.
So.
But the way the collegium system functions, appointing their own kith and kin,
Hmm.
that should not also be there.
Hmm.
Okay. There are three organs of the government: judiciary, parliament, and executive.
Right.
Legislative, executive.
Hmm.
Judiciary should be always independent. There is no question about it.
Right.
But lawyers are not happy with the way in which now judges are appointed through collegium. Kith and kin should not be. At
Right.
least they should think about that. And whenever there are allegations made against the Supreme Court judges, that particular judge should at least, in the
Hmm.
interest of fair justice,
Hmm.
should refrain from acting as a judge for at least the period the investigation is carried out.
Right.
There are allegations against the CJ then also.
Right.
I don't want to name it, but even sexual harassment, etc. The judge shouldn't be suspended, or in a way they should. They're going to say in India they say impeachment. It is not
Right.
easy to remove a judge. The parliament majority should be there to remove a judge. That is only by way of impeachment it can be done.
Hmm.
Removal of judges. But when any corruption allegation or sexual allegation against any judge,
Right.
that should all duties he should be relieved of all functions or all duties.
Hmm.
That should give at least an apparent method in which people can restore their faith. Otherwise, if the same person is sitting as a judge and investigation is carrying out, then there cannot be a fair investigation. First,
Understood.
stepping down from that post would reinforce the faith of the public at large in the
Hmm.
judicial system. That is not found at all. That is something now even lawyers are against this kind of practice in court. And recent example of the corruption
Right.
after that fire, finding so much piles of a bundle of notes. The first thing should be the from that person, very judge should have resigned. I mean, not
Exactly.
resigning. I am not saying if not resigning, at least he should be relieved of his duties.
Right. I mean, it's really sad to see this part of corruption. Corruption is being in. I mean, we can see in judiciary as well. That's really sad.
Very sad. Very sad.
So, would you think while reintroducing the bill, you think some of the global models of legal regulation could be adopted by India?
India's model is finest. Even in Western countries, even advertisement to that extent
Hmm.
are not expecting in India. The dignity should be maintained.
Right.
So I find the situation and the mechanism of Indian Bar Council and Bar Council of India are fine enough.
Hmm.
There is nothing that we should compare.
Right.
Always comparing with other countries. Our system is far better.
Hmm.
I like the Indian judicial system and the way it functions. Except the collegium system now,
Hmm.
that is what bringing bad name to the judiciary.
Right.
Other things are very, very much, and moreover, number of days the Supreme Court judges are functioning.
Hmm.
That is what another criticism. They want to increase the judges, even High Court and Supreme Court.
Right.
But the number of days they are functioning, that need to be taken into account. So,
Understood.
so many holidays, Saturday, Sunday, leave, all these things. These are of judiciary. But see, it would be better if the lawyer community come forward and give suggestion, and they are demanding some amendments.
Right.
That is fine, rather than from the government.
Hmm.
Okay, when government imposes something and they want to intrude and interfere, then it doesn't look nice,
Right.
because it will be direct infringement of their own domain. I
Hmm.
mean, their expertise. So I expect lawyer community should come forward. Even BCI, State Bar Council should recommend what they really want, rather than government coming out and imposing some amendment on us.
Okay. So we have some questions as well from
Yes.
our, audience. So let's begin with that. So the first question is from Avinash. What opportunities are included for lawyers in this bill?
Opportunities. As
Yes.
I said, women,
Mm.
their participation, there should be minimum, as I said, in bar council, advocates in bar council membership.
Mm.
It was not there. So women's participation is it is welcome.
Mm.
So that is one thing. And legal practitioners, even those who are practicing in a corporate, private, or government, they are also considered to be legal practitioner. It will boost their moral in one way.
Right.
That also I welcome. So these are, to me, good steps taken by the government in this bill, and that should be reintroduced. And that is it. And as far as uh, now the fee, those who want to enroll as an advocate, there are certain things. If any advocate facing trial for an offense punishable with 3 years or more cannot be disqualified from contesting elections.
Mm.
This is one thing that is I'm against it.
Mm.
Even without conviction, a person shall be deemed to be innocent until and unless his guilt is proved.
Yes.
So even here there is an allegation,
Mm.
barring or disqualification to be, participate in the election. That is something bad about.
Mm.
So that I don't support.
Right.
And there is, as far as juniors advocates are concerned, this legal profession
Mm.
is such that you need to practice for n number of period
Right.
under a senior. That is a traditional practice,
Correct.
and it is not that it's not a cakewalk.
Mm.
Junior has to learn.
Mm.
And now, as far as lawyers are concerned, there's an internship
Right.
mentioned in the new proposed amendment bill that after education, after the graduation, you have to practice internship with a advocate or
Senior.
law firm.
Yes.
That is one thing, and it should not be a must,
Right.
because there is an advocate who does not have a family background of law. I mean, there is no lawyer in the family.
Yeah.
Cannot be compared with the one who doesn't have that history.
Right.
Okay, because there his father, grandfather, he doesn't need an internship as such.
Right.
He's trained. Now, it should not be forced. The 5 years not a small year to complete law.
Right.
After that, again internship, something that can be in misused by senior lawyers, not paying them.
Right.
You have to do internship. So it should be optional. It should be left to the advocates. I mean, lawyers. Intern. And now AIB exams also there.
Mm.
In my time, there was no AIB exam. After completion of the LLB course, I directly became enrolled under the Bar Council of Kerala.
Mm.
Then I started practicing as a junior under a senior.
Mm.
Now there's AIB exams. 5 years exam you completed. Thereafter another test AIB exam. There also you want to intern with.
Right.
When they will start earning. Suppose a
Exactly.
person.
I mean,
Yes.
when I was doing my BBLLB, so during the 5 years, I had the mandatory, assignment and sort of report where every year after my final sem is done for that year, I had to go for internship for at least a month.
Mm-hmm.
So in that manner, I had 5 internships of 1 month each.
Mm-hmm.
But in that time, the problem was that I was not being paid. And because I was interning, the advocates, thought was since I'm learning, so there is no need to pay. That
Mm-hmm.
was good. But after graduating, I had to appear for AIB. First, I had to collect the sanad, then I had to appear for AIB. So that the whole process there. So exactly, what you have mentioned that when the learning would start.
Mm-hmm.
That
And
we
now, especially it is there's a much difference from the kind of practice that we had from the starting and now the new graduate. Now, because of AI tools, artificial intelligence,
Yeah,
the drafting part can be learned very easily.
easily. Correct.
Language won't be a problem.
Oh,
Even a person who knows basic knowledge of the language, he can draft beautifully
right.
because of AI tools.
Right.
Even seniors nowadays, they are not using AI tools as expected.
Mm.
And the juniors, they use AI tools, and the drafting part is, if compared, far, far better than those
Oh,
called experienced advocates.
right.
Now we use AI tools. I tell every junior to learn it, and I teach them also how
Mm.
to use cloud, how to use ChatGPT, and this kind of tools. How can they empower? How can it empower them to
Right.
draft beautifully? So this concept of a senior is taken by Google's. The
Mm.
concept of senior is taken by artificial intelligence.
Right.
Only what they need is to be trained. And what really happens if a junior goes to big law firm? They carry the file, they go along with the senior, they stand behind and beside him in the courtroom. This is what expected of. Now, rather than that, if they are taught how to use the intelligence, how to use the cloud, ChatGPT, Perplexity, etc., then they can at least take part of the drafting side. And
Exactly.
much of our time is spent on drafting. And we
Right.
go to court, and the court, the problem is that we have to sit morning till evening sometimes to for our turn to argue the matter or
Right.
to address the court. Then it will be a criminal waste of time. By the time, if the junior is instructed, he can draft well,
Mm.
or if the junior is given the material, or if a small IAS, if small matters can be argued by the juniors, and they can sit in the office, they can do the major drafting work.
Right.
But this kind of exposure to be given to the juniors by the seniors, and they should be paid. That is one thing very alarming. Whether juniors are paid or not, as you said, this is a learning time.
Right.
Thereafter, you can earn.
Mm.
Now, especially boys, I'm not talking about girls because boys they can't ask money from their parents after graduation.
It
Or
becomes
girls we not ask because parents will give automatically to them
yeah.
for girls. So this I tell even the boys and girls when you are thinking talking about equality. Now, if a girl goes to home, the parents would provide food and tell, "Beta khao." If a boy comes and says, "How much you earn?"
Right.
So this is a very embarrassing situation for
Yeah.
boys. So they should earn and learn at the same time.
Exactly.
And 5 years good enough.
Mm.
And thereafter, they are also expecting money.
Right.
That's something that we should not neglect
Mm.
or avoid or silent or put under the carpet.
Right.
Earning should be there as well as learning, and we can provide both if
Right.
we are
Exactly. But it's good to know that senior lawyers like you are addressing these issues and also adapting the role of
no,
AI.
we know the reality. Now, see, we were also
Yes.
juniors, and we
Right.
were under one senior. We were also expecting money.
Right.
Now the same routine that first you learn, then earning will come.
Right.
Now, because I have gone through it, and I respect those seniors, I learned a lot. Even some seniors paid me well.
Right.
So, see my own experience.
Mm.
I see to that my juniors should not, say something bad about me behind my back.
Right.
So even their interest financially also I have taken care of, not only of boys, it's
But
also of girls. Now
right.
girls also telling me that no, we don't want to ask money from parents because they have given so much to us. That's a good side of thinking from
Right.
the part of girls as well. They are also considering equal to that of boys, and they want to give back to the parents. That is something everyone should try to.
Right. We have one more question. The legal profession is often seen as slow and complex. Would this bill have helped in speeding up justice for clients?
No, nothing. See, I don't think so. Because if that is the main interest of the government to see that, then they should not interfere in the bar council rules and state bar council powers.
Right.
They should set up a number of courts. They should deploy judge, appoint so many judges. If that is the main concern of the government to
Mm.
see that speedy disposal of the cases, then
Right.
they should not interfere, because we are well equipped with controlling advocates and rules and regulations.
Right.
Government should think in a different manner. Set up various courts. Number of judges should be increased, and see that cases disposed. And there's a management system. See,
Right.
if there are 100 matters on the board in a particular court, 50% or more than that, 80% they adjourn the matter.
Right.
Okay, for this very adjournment, if they are utilizing majority of the time, only small portion is left for conducting the real cases. I mean, main cases for argument, which are important thing. Why not a management system wherein advocates concerning party can take adjournment not from the judge, but by the officer concerned, court assistant concerned, rather than bringing the matter to the court and court adjourning it by mutual consent, etc. All the mutual consent can be done away with, and they can fix for final argument. Mere for adjournment, I don't think judge is required. That time can be utilized for argument.
Right.
Okay, so
Understood.
we can see the matter when called out, it is urgent. So these are things which even judiciary, the High Court rules, Supreme Court rules, they are also given powers to pass rules, guidelines, etc. They can do that very well.
Right. Well, this brings to the end of this productive discussion.
No,
And
see, I thought of there are a number of sessions which are in favor of advocates. There are a number of sections which are against advocates. So
Right.
I thought if the discussion goes as I thought there will be panel advocates. So we could have mentioned, see, 7B, 30, 23, 3, and ultimately the important provision which is introduced is 49B.
Yeah, you
Which
you
is
can surely discuss it, sir. Not a
Eh?
problem. You can surely talk about it. Not a problem.
Yeah, so I thought one by one, then it would take more than 3 hours. But important thing I can say that what they introduced as a new provision is that power of central government to give directions.
Right.
Why should government give direction to the Bar Council of India?
Exactly.
No, can they give direction to Supreme Court? Okay, then BCA power to verify place of practice, etc. See, one has to understand the rural areas. Even still, digital is not that much used by the many of the advocates, senior advocates, and there the verification after every 5 years is something it's like a harassment in a way.
Exactly.
That is one thing, and you can see professional development fees 30%. As we said, what are the good things about the newcomers? They have to pay extra 30%. That is one thing. If an advocate is convicted and sentenced to 3+ years, and conviction is confirmed by an High Court and Supreme Court, they can be removed. But what about suspension? If the conviction is done, it can be suspended. It has to be very clear.
Right.
When the suspension, if suspended, then he can practice. Then after confirmation, he can be. See, the advocate can be removed as per 26A(c). Advocates can be removed from the role if they are found guilty of obstructing court functioning. Obstructing court functioning.
Right.
Okay. What is that obstruction is not explained.
Exactly.
Okay, now a situation now the same now, because all are taking the corruption, and now advocates protection against this kind of transferring the judges to Allahabad transfer. Then the advocates can be removed.
True.
So obstructing means that in a way obstructed that suppose all the advocates who are supposed to be there in a particular court did not attend the court and they were in the protest.
Right.
They can be removed.
Yeah.
That is another thing. Then BCA empowered to regulate state bar councils election and to constitute election tribunals to resolve disputes. That is something where shift control local democratic elections by the BCI, Bar Council of India. They can handle it themselves.
Yeah, exactly.
Bar Council of every state can. So it is something that they want to split in a federal, union government and the federal government. Now they want to centralize. So a rift between the Bar Council of India and State Bar Council.
Right.
Divide and rule.
Right.
So these are there are more sections
No,
which
I'm
we
sorry.
could have detailed in another session, but good to have this one. So I have a mixed feeling, mixed response to this bill. Some provisions, as you said, are good enough, and some
Right.
provisions are which against the interest of the advocates, we shouldn't be done away with. And if government is rethinking, then government should think that not to interfere in Bar Council of India and State Bar Council. They
Correct.
should be respected. Their freedom should be respected. Respected the way the government is respecting the freedom of the judiciary.
Right.
I have a problem with that. Now the question is that why government is not taking initiative against impeachment of corrupt judges. They should have intervened. I am saying that independence of judiciary does not mean that government cannot take any action
Mm.
against the judiciary as stated in the constitution.
Right.
They should also come forward.
Right.
Why not they are coming forward? Judiciary will not leave any person who is a corrupt from the parliament or executive.
I
They will
think
have this judgment, they will have the statement. Accordingly, the central government should also be very strict about this.
right. I think excessive interference is somehow becoming a problem. And
Judiciary started legislating.
yeah,
That is something, that should not be. The government, it's the fault of the government. The government should not be subservient to judiciary.
mm,
They are equal.
correct.
Parliament, executive, judiciary are equal. Judiciary is not above it, but only thing is it has got independence. That is for the good of the democracy only. Otherwise, every time government should interfere 100% when a
Yes.
corrupt judge is found.
Yes.
Government is silent. So government should think about all those things. And regarding advocates, we have a good system, and advocates are capable enough to govern themselves. And whatever the financial need or support is required, government should come forward. And rest of the powers, as far as Bar Council is concerned, State Bar Council is concerned, they should be given total independence. There should not be third-party nomination. There should not be direction to Bar Council of India.
Understood.
Bar Council of India should not be a subservient to even the government. It should be always under a part of judiciary, which has
Right.
to maintain independence.
Right.
Okay, I am taking too much time of yours.
No, that's okay, sir. That's
Okay.
no problem. So I think it was a very insightful discussion on whether the withdrawal of advocate bill was an end. But surely I don't think it's an end. It's probably a beginning of new reforms. And it was great to have you, sir. Thank you so much for joining and
And
discussing this.
and thank you for having me on this discussion. And one thing I had to add, Section 30, which says that if you are registered under one bar council, he can be allowed to practice anywhere in the rest of
Right.
the states. That is beautiful thing, which even in the old act in the 1961 also recently it has been enforced. So that is one what that has to be. In India, we can practice throughout. That is one thing should be given to the advocate, the right to be given to advocate.
Correct.
With that note, good note, I expect the government should reconsider, and with the full consent of the concerned authority, Bar Council of India, Bar Council of State, in a joint meeting, in a joint discussion, they will remove all those things which are against interest of the advocates, and they will come up with the good points, good section, good provisions, which they thought of amending it.
Right.
Thank you so much.
Thank you so much. Thank you, sir.